Welcome back, Law Nerd. It's time for another Emily show. And so much happened last week that isn't all going to be resolved by the time I record this and this goes live. As we talked about on stream, I am traveling this week. So as there are updates to the things we're talking about today, I will share them with you in the Law Nerd app. Because today we need to talk about a lot of things that went down on Thursday, including singer David being arrested, but not yet charged. And what does that mean? And what happens next? Karen Reed has been sued again, and there is one actual quick update in the disappearance of Nancy Guthrie. We have a lot to talk about. I had hoped we would get to talk about Ticketmaster today, but it's going to have to wait for the next one. So don't worry, that will be coming. But today there was so much breaking news that we are going to cover that. First, Law Nerds, I promise you we will circle back to Ticketmaster. But for today, let's get into it. I'm legal analyst Emily D. Baker, yes, also a lawyer, and this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. I think we should just start with a quick update about Nancy Guthrie, because if you are still looking for information on this case, it has gotten further and further between updates. We haven't really heard anything official from the Pima County Sheriff. We know that the county is talking more about the Pima County Sheriff, as we covered in past episodes, and I am keeping an eye on that. So when there is an update, other than they're having hearings and trying to figure it out, I can update you. But as for Nancy Guthrie, you might have seen some updates about DNA. And I saw a ton of confusion about this. It's always my goal to try to help bring us back to what we know and then also clarify what we don't know. And in the Nancy Guthrie case, it's getting really frustrating, and I'm sure you're feeling it too, because what we don't know is actually so much, and it has been so long since she went missing on February 1st. It's just incredibly frustrating. But the updates you have seen about DNA are simply that some of the DNA samples that were collected, or some of the samples of biological evidence that were collected from Nancy Guthrie's home, have now been sent to the FBI to do some additional type of extractions that the lab that they had originally been sent to weren't doing. And that is updated DNA technology. So it is using hair to extract DNA, even when the hair doesn't have a root attached to it, which is newer technology. However, does that mean that's from a perpetrator? No. Does that mean that's from a human? Not necessarily. I mean, I hoped that they would have checked it microscopically before they do a DNA extraction, but do we know much more about what was recovered? No, we don't. Could that be from someone who had visited the house at another time and isn't connected to any of this? Yes. But what it means is they are still trying to follow up leads. They are still trying to follow up with additional scientific testing, and the FBI is doing testing in addition to the lab that Pima County Sheriff regularly works with, where information was sent out at the beginning. Unfortunately, it's just getting to the point of the case where things are moving a bit more slowly. And so what I'm noticing on social media is people jumping to force updates that don't exist, jumping to conclusions that aren't founded in facts, and jumping into more speculation, because the longer this case goes and there's nothing known, the less optimistic I think the public becomes, and that's really hard too. But there is still scientific testing going on. Some of the last scientific testing did not yield any results for any potential suspects, and that is frustrating to know. But what's going on now is not new. It's not new DNA evidence that was recovered. It is a new way of testing. Same things that have been recovered, just now being tested by the FBI. And that's what's going on. If there are more updates in this case, I will keep you posted in the Law Nerd app, but there is going to be, and there is a growing amount of really just jumping to conclusions that aren't founded. And I worry that that's going to continue to get worse in this case and not better, especially as the Pima County Sheriff himself, Sheriff Nanos, comes under more fire by the Board of Supervisors in his county and others. And there are some real questions there that I'm not going to stop looking at, because we're going to be turning our eye back to Pima County in a separate update. There's just so much to get to today that we don't have time for another deep dive. But don't worry, as the Board of Supervisors in Pima County looks at whether they're going to try to remove Sheriff Nanos, I am going to keep you posted because now I'm invested. I want to know what's going on. I'm invested. Hopefully you are too. But there were two other stories that broke late in the day, Thursday, April 16th, that after I finished streaming, we just haven't had a chance to talk about on Thursday. So we're talking about them today. However, from the time I record to the time the podcast goes live, you know what's going to happen in that span of time? Emily's going to have to get on a plane. And you know what I tell you about when Emily gets on a plane? We have seen this true every single time. Stuff goes crazy when Emily travels. It's just going to be. But I'm going to be traveling. I'm going to do my best to keep you updated in the app as things happen, because with regard to the David arrest, he is supposed to be in court on Monday, the 20th. Yes, it's 4/20. Yes, it's Corey Richard's birthday. No, nobody's bringing her big cookies, but he will be in court Monday afternoon after being arrested Thursday. We can have a whole discussion about how that works at another time, but Singer David was arrested Thursday afternoon by LAPD. He will be in court Monday afternoon, presumably for arraignment, but there's a lot of information that we need to talk about because this is a very, very interesting turn of events, given what we know. For those of you that have not been keeping up with the David case, let's do a real quick kind of road so far as we get into our criminal docket before we get back to the civil docket. Hey, Leonard, just time for a quick chat about today's sponsor, Honeylove. Look, it's that time of year where there are a lot of events going on, but one of the things I'm not panic buying is shapewear and bras because Honeylove absolutely has me covered. And if it's been a minute, Honeylove has some exciting new bras, including the Cross Flex Activity Bra. First of all, it is so much better than the sports bras that you're used to that are uncomfortable and dig in. This is support like a sports bra, but comfort like your favorite bra, all in one. And you never know, you might just find yourself like me reaching for a sports bra for your everyday bra because it is that comfortable. And yes, that is what I'm wearing every day that I'm streaming. And Honeylove is now offering a crossover triple bra bundle. So if you want a full refresh of your top drawer, you can get huge savings when you buy 3. Don't miss their new crossover contour bra, which you will also love. You know that Honeylove is an independent female-founded company, so products are designed by the people who actually wear them. And while you're checking out the triple bra bundle, don't forget to look at their shapewear and sleepwear. So Leonard, if you are ready to treat yourself to the best bras and shapewear, and I think sleepwear, on the market, use our exclusive code to get 20% off Honeylove at honeylove.com/Leonard. That's right, honeylove.com/Leonard. 20% off. And after you check out, if they ask how you found them, let them know it was the Emily Show. It's time to experience the new standard of comfort and support with Honeylove. Now let's get back to today's episode. Some of you may be familiar with David from music, from streaming. Some of you may just be familiar with him from this case, connected to the death of Celeste Rivas. Celeste Rivas was a teen who went missing from Lake Elsinore, California, originally around Valentine's Day 2024, but was reported missing April 5th, 2024. She had had periods of being in and out of her home and was largely connected to David. Many have said that his friend group believed that she was over the age of 18. I think we will see that sorted out a bit more as we move through this case because there will be a lot of questions. Either way, David was heading out on tour over the summer. His vehicle had gotten moved, and when the car got towed, the tow yard reported a distressing odor coming from the Tesla that had been towed off of the street near the rental where David was staying. Los Angeles police responded. They located remains in the front trunk of the Tesla, and those remains were identified on September 17th as belonging to Celeste Rivas. Now, the remains had been found earlier in September 8th, and it seemed from everything we know from the coroner's department that she had been in the car for some time based on the state of decomposition. But after she was identified, there's some mixed reporting on her age. Sadly, it seems that she passed before her birthday, not after. So as we talk about Celeste Rivas, I refer to her as being 14 years old because I believe that she was deceased before she would have turned 15. So you might see some differences in coverage as to victim Celeste Rivas's age. Then began a very long period of the internet trying to look at her connections with David when she had been on stream with him, things he had said in music, and where was this investigation going? Then some odd updates, one from the coroner's office in November 2025. Statement on medical examiner case number 2025-14252 on Friday, November 21st. The County of Los Angeles Department of Medical Examiner, the coroner's office, received a court order initiated by the LAPD to place a security hold on medical examiner case 2025-14252, Celeste Rivas Hernandez. No records or details associated with the case, including the cause and manner of death and medical examiner report, can be released or posted on the website until further notice. Remember, we've gone to the coroner's website and looked at that information with relation to the death of Rob and Michelle Reiner. You can normally see some initial information on the coroner's site, but this case was pending and then it was sealed by a report from LAPD. They go on to say, quote, "The department's mission is to have full transparency with the community by providing information about our cases to empower people to make changes that save lives," said the chief medical examiner. Quote, "Since becoming the department head, I've worked on eradicating the practice of placing security holds on medical examiner cases simply by law enforcement request. The practice of security holds is virtually unheard of in other counties and has not been proven to improve outcomes in the legal system. We are dedicated to serving our community with full transparency. However, the law precludes us from doing so while the court order remains in this case." So the coroner's department was like, this is not our practice. You can't just come and ask us to seal things. However, once the court says this is sealed, the coroner's office has to adhere and abide by the court's order. They go on to say that the department previously received a request for a security hold from LAPD in this case on September 15th, 2025, which was denied due to insufficient justification to warrant the hold. So LAPD was like, can you hold this? And the coroner's department was like, nah, we're not. But at that time, the case was still pending. They go on to say that the department understands the public's interest in this case and remains committed to transparency when possible. Information will be made available once the court order is lifted. Just a note, that has not been done yet. And then they go on to talk about how to reach out for questions about that order, but that has not been done yet. So I have seen, and you might have too, a lot of reporting about what the coroner's office might have said, how they might have determined this case and what's going on. Part of that's because around the same period of time, we started hearing rumblings that a grand jury had been convened in this case. And then I covered the fact that one of David's friends, Neo Langston, who's also a streamer, was arrested in January 2026 out of the state, out in Montana, and brought to California to testify at grand jury. So there has been an ongoing grand jury. So when I saw that David had been arrested by LAPD on Thursday, my first thought was, I wonder if they returned a grand jury indictment because we knew that a grand jury had been convened. However, there were conflicting reports about whether that was an investigative grand jury or not. And it might have been. There are times that a grand jury will be convened to investigate a case, ask more questions, get subpoenas, get more documents, and move forward that way versus a grand jury that's going to ultimately charge someone at the end of that grand jury. And grand juries don't always sit day after day after day. Sometimes they convene one day a month or one day every other month. We don't know the last date that the grand jury in this case heard evidence in this case. And I don't know when that round of grand jurors was up for being done with their jury service. There's also times when you have a grand jury convened and then they time out. So I still have some questions about the grand jury. There's been lots of speculation because when news came out Thursday that he'd been arrested and there was not a grand jury indictment, it raised a lot of questions about why, if there had been a grand jury in this case, would LAPD just go arrest somebody? Well, it can depend on a lot of factors. CEG Donna Adelson. That is the thing that comes to mind first for me. CEG Donna Adelson. Why did they go arrest Donna Adelson when they did? Well, because she was at Miami International Airport. Now, David was not arrested at the airport. He was arrested at a home that he was staying at, but There can be a lot of factors as to why an arrest happens when it does. Unfortunately, we're not going to be able to connect those dots until we have more information. But when he got arrested late in the day Thursday, that means he will be arraigned on Monday. Do not expect this to happen first thing Monday morning. I mean, I'll be on a plane. Do not expect this to happen first thing Monday morning. Those will normally go through the clerk's office and not be arraigned until the afternoon on Monday. So I would not expect David in court till after 1:32 p.m. Pacific on Monday. Maybe it will get done faster than that. That would be optimistic, but I wouldn't wait with bated breath thinking that at 8:30 a.m. Pacific, we're going to hear what charges are being brought against David. And if charges are brought, I imagine that the elected DA in LA, Hochman, will have some type of a press conference, maybe with the DA that had been doing the grand jury, Beth Silverman, who's also in that major crimes unit with the DAs that are prosecuting Nick Reiner. So let's talk about where we're getting some of this information from, shall we? First of all, LAPD has put out some information that I was a little like, is this it? This is what we're doing. This is where this information is coming from. Okay. Thanks for that. But this is the Public Information Officer LAPD X account. LAPD News, quote, detectives from Los Angeles Police Department Robbery Homicide Division have arrested David Burke, a 21-year-old resident of Los Angeles, for the murder of Celeste Rivas. Burke is being held without bail. The case will be presented to the district attorney's office on Monday for filing consideration. For filing consideration. This is not an arrest that happened because charges were already filed and there was an arrest warrant. Something else triggered this arrest. We do not know what it is yet. That annoys me as well. Maybe we'll find out. Maybe it'll take some time. It was a little easier to piece together the puzzle with Donna Adelson because she was literally arrested getting onto an international flight. But we don't know yet what's going to happen. I'm interested to see. Oftentimes, especially in high-profile cases, you'll have charges and then an arrest warrant, or an indictment and then an arrest warrant. Here we had an arrest and then presented for filing consideration. And I think we will see the LA DA's office file it. Now, it might have just been that the LA DA's office was like, no, go get him. We're ready to file, but go get him. And then in LA, because you have 2 court days for arraignment, they wouldn't have arraigned him on Friday. It'll come in on Monday. But I'm keeping an eye on this. It's a question for me. Why they chose to arrest now, why they arrested before charges, what was happening. That is what I'm curious about. But that's not all that LAPD shared on social media. LAPD HQ also shared images from LAPD Robbery Homicide Division rolling out for the arrest on Instagram. Literally last place I would have thought to check to find out more information about the arrest was Instagram. It's not front of mind for me. The quote was, LAPD Robbery Homicide Division, along with the assistance of Gang and Narcotics Division, arrested David Burke for the murder of Celeste Rivas, and showed pictures of them in the neighborhood to go arrest David Burke. And so as you see the photos, it's also clear that some of the task force members are also with the marshals, because you can see them on their vests, and you can see them rolling up to go arrest David, who was arrested without incident. And then his lawyers also put out a statement. This is coming to us from the LA Times from April 17th. New details emerge about the arrest of singer David in the killing of teenage girl. Details are emerging about the arrest of David in the 2025 slaying of a girl, Celeste Rivas Hernandez, in Hollywood. They've added some details there that haven't been confirmed yet. However, since LAPD is holding him for a murder charge, it seems that murder charge is what they are talking about. Remember, LAPD had said earlier in this case that they needed to figure out what caused Celeste Rivas' death, because moving someone after they die and killing them are 2 very different circumstances. And you have to figure out how someone died and what caused it before you start addressing how she ended up in the vehicle in the first place. So there have been some questions about that throughout this case. They go on to say that the singer known as David, full name David Anthony Burke, 21, was taken into custody shortly after 4:30 p.m. in Hollywood and booked at LAPD's 77th Street Jail hours later. They go on to talk about where he was arrested. The road sits off of Sunset Boulevard on a celebrity-filled lane where the likes of Kendall Jenner and Emily Blunt have lived, and where Jimmy Kimmel once described himself as the neighborhood watch captain. So Hollywood shit. They go on to say, on Thursday afternoon, a procession of LAPD vehicles proceeded up the narrow avenue, blocking access to the road on either side of the property. At some point after 4:30 p.m., detectives with robbery homicide entered the home, announced themselves, and arrested David, who they say came out and surrendered. They go on to say that he was formally arrested at 5 p.m. They continue that Burke is being held without bail, and the case will be presented to the LA County District Attorney's Office on Monday for filing consideration. Burke's attorneys, Blair Burke, not the same spelling for those of you listening in the background, and yes, it's going to get confusing, so I'm just going to refer to him as David, even though it's spelled D4VD. It's going to make it easier. Attorney Blair Burke and others released a joint statement after his arrest saying, quote, "Let us be clear, the actual evidence in this case will show that David Burke did not murder Celeste Rivas Hernandez, and he was not the cause of her death." We are turning now to an article from People, updated April 17th, with a statement from the district attorney's office. Their article is called "Singer David Arrested After Missing Teen Girl's Body Found in His Impounded Tesla." They add a statement from the LA County District Attorney's Office that says, quote, "The office is aware of the arrest of David Anthony Burke by LAPD. The case is expected to be presented to the Major Crimes Division, at which point prosecutors will review the facts and the evidence to determine whether there is sufficient evidence to file charges." Like, that's what they do in every case. That's just like, this is the procedure. They go on to say, "At this time, additional information is not available. We will share an update on Monday once a filing decision has been made," which means if they file, if they don't file, and what charges they file. People has an expanded statement from the defense attorneys that includes, "Let us be clear, the evidence will show," but then goes on to say that there has been no indictment returned by any grand jury in this case and no criminal complaint filed. David has only been detained under suspicion. We will vigorously defend David's innocence. So that is an expanded statement from the defense as reported by People. People goes on to note a prior statement from the LAPD captain, Scott Williams, who had previously said that Rivas had likely been dead for several weeks before her remains were found in the trunk, which is consistent with prior information we had from the coroner's office talking about the difficulty of autopsy due to decomposition. And on Saturday, Celeste Rivas' family made a statement about the arrest. I saw that first shared in Los Angeles Magazine, who's been covering this quite a lot. Their headline says, "Celeste Rivas Hernandez' family invokes Marsy's Law ahead of David arraignment." Marsy's Law is the California victims' rights law, so you will hear it referred to that way, but it informs what stages of the proceedings the victims have to be notified about, be taken into consideration, and lines out and governs that to make sure that things don't happen, like a case shows up on arraignment and pleas and the victim's family never even knows that there was an arraignment or a plea deal or anything like that. So that is a very, very broad oversimplification of Marsy's Law. They go on to say that after Burke's arrest, the teen's family hires a wrongful death lawyer and invokes Marsy's Law to ensure their voice is heard. The article goes on to say that in a statement released to them prior to Monday's expected court proceedings, the family stated through their attorney, Patrick Steinfeld, that they intend to, quote, "fully participate in the criminal case following Burke's arrest." Burke, 21, is reportedly scheduled to be arraigned April 20th in Los Angeles County Superior Court. There is not an arraignment date set. If charges are filed, then he will be arraigned on Monday. However, we will get back to that in just one moment, because we have seen a lot of times that arraignments get continued even if someone is in court on that date. They go on to say that he is currently being held without bail and that this comes after a grueling 7-month homicide investigation. They go on to say that the family plans to attend both the arraignment and the Los Angeles County District Attorney's press conference in a supportive role. I mean, I guess if there is a press conference, or we're going to read this whole statement. Are they already planning for a press conference? If they're already planning for a press conference, it sounds like they know they're going to file charges. It sounds like they know he's going to be arraigned Monday afternoon, and everybody's already been made aware. Sure. They go on to say that they will attend the press conference in a supportive role, but will not speak publicly during those proceedings. The entire press release from the law firm, and this is highlighted in the news article not by me, says that, quote, the family of Celeste Rivas, 14 years old, whose dismembered body was found in the trunk of a Tesla owned by David Anthony Burke, intends to invoke their rights and fully participate in the upcoming criminal court proceedings under the California Victims' Bill of Rights Act. David Anthony Burke is scheduled to be arraigned on Monday, April 20th in Los Angeles, following an exhaustive 7-month homicide investigation. They say Celeste's family plans to attend the arraignment and the district attorney's press conference in a supportive role, but will not be making any statement at the time. The family will be available for brief comments outside the courthouse after the DA's press conference. Patrick Seinfeld, the attorney for the family, said, quote, the Rivas-Hernandez family is committed to ensuring that Celeste's voice is heard and her memory is honored throughout the process. The family remembers Celeste as a daughter and sister whose loss deeply affected those who knew and loved her. They go on to say, in learning of Burke's arrest, Celeste's father, Jesus Rivas, said, quote, thank God, justice for Celeste. 7 months is a really long time for this family. I'm sure it's felt infinitely longer than that. And a lot of you know that we record the podcast with our wonderful Lawnerd members, and the members had a lot of questions because we have not really talked about the fact that Celeste Rivas's remains have been described as not intact. Some have described it as dismembered. Some has described it as not intact. And with the level of decomposition, I have been waiting for more information from the coroner's office, which is now sealed. We might learn more when we see a complaint, but there has been conflicting information about the state of her remains. I am waiting until we know a bit more, but yes, her remains were not intact. Some have used the word dismembered. Until I know more, I am not going to say one way or the other because we just don't know enough quite yet. So what happens next in the David case? Well, hopefully we will know more by the end of the day Monday, including what charges have been filed by the district attorney's office. It seems that the attorney for the victim's family is under the impression, at least, that there will be charges, there will be an arraignment, and there will be a DA's office press conference. If those things happen on Monday, I will be breaking them down for you in a notification. But remember, in other high-profile cases, we have seen charges, we have seen people come for arraignment, and we've seen the arraignment get put over. What happens at arraignment? Well, the defendant's advised of the charges against them and their rights. They can argue over bail at that time or put that over until later, and they can start setting dates, and an attorney can be assigned. There is always a period of time when there are new filings before that individual arrives in court. So if you are waiting to see what happens on Monday, remember, A, we're in Pacific time, and B, it will happen in the afternoon on the court day on Monday, and then we will know more. But since the identification of Celeste and since remains were found in that Tesla, it's been a long journey to get to the news that David has been arrested. And I'm very interested to see where we go from here. I will keep you posted. Let me know if you want to keep following along with what's going on here as this case, well, maybe sees charges and gets underway. And I imagine we'll see David remaining in custody, at least initially, if charges are filed. Now, if charges are not filed, then he would be released from custody, and that's a whole different conversation. But we're going to have that sometime later this week, I think. I mean, Emily's getting on a plane. Who knows what's going to happen? And speaking of who knows what's going to happen, we have one more case that we need to talk about because Karen Reed got sued again. Lawnerd, just a quick minute to talk about my hair. Well, because you're talking about it in the comments ever since I got it cut, and I know I've been wearing it down more, but part of that is also today's sponsor, Oneskin. And I know when we talk about Oneskin, we are often talking about their skincare. But Oneskin also makes OS1 hair, and it's with the same patented OS1 peptide that is scientifically proven to target aging at the cellular level, the same one that they use in their skincare, but targeting aging related hair loss and thinning. I know. The scalp serum, you just put it onto your scalp with the dropper. It doesn't make your hair oily or greasy, so it doesn't disrupt your routine or your wash day routine, and it actually helps reduce shedding, and you'll notice that your hair is feeling fuller. So if you're ready to check out Oneskin OS1 hair, now is the time. Born from over 10 years of longevity research, Oneskin's OS1 peptide is proven to target the cells that cause visible signs of aging, so your scalp and your hair stay healthier now and as you age. And plus, we've got a discount for you. For a limited time, try Oneskin with 15% off using code LAWNERD at oneskin.co/LAWNERD. That's right, 15% off with code LAWNERD at oneskin.co/LAWNERD. And after you purchase, if they ask how you heard about them, let them know it was The Emily Show. Now, let's get back into it. A new lawsuit against Karen Reed. Well, not just Karen Reed. Also, Aidan Kearney, who you probably know by the handle Turtle Boy, at least if you've been following this case for some amount of time. Now, I just need to give a disclaimer and a reminder, as when we are covering the initial stages of litigation, the way that I approach it. Because there is a lot going on in this defamation plus suit that we could sit here based on the trial and just go back and forth and, well, actually the entire thing. Yes, that is not how I generally approach first filings, and it's not how I'm going to approach this first filing. We are going to take a look as an overview today. If we need to do a deep dive, we will. We don't have a time to do a 50-page deep dive today, but we are going to take a look at an overview of who is suing. You can probably already guess what they're suing for, defamation and more, and where this goes from here. There is a ton of information about this case connected to the other Karen Reed cases and connected to other Turtle Boy cases. I have not covered any of the other Turtle Boy cases that are moving through the courts. I think we've covered all of the Karen Reed cases at this point, including Karen Reed being sued for wrongful death by the estate of John O'Keefe, John O'Keefe's family members et al., where she is co-defendants with the Waterfall and C.F. McCarthy's. Karen Reed suing those that were inside the house in federal court, including Proctor, Tully, Buchanan, for malicious prosecution, conspiracy, deprivation of rights. We covered that on stream last week. When I covered these things on stream last week, I covered them because there was so much going on with Proctor's phone. I had no idea that this was going to happen. I had no idea there would be another lawsuit. And then on Thursday, new lawsuit. So let's take a look at an overview of, well, the next civil lawsuit in what in the world is going on in Massachusetts. So what we are looking at now is a 50-page civil complaint filed by Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins. This was filed on April 16th, 2026 at 12:48 p.m. Eastern Time in Barnstable. This is not the same group of defendants that Karen Reed is suing. This is a different grouping of individuals, and they are also suing Aidan Kearney, aka Turtle Boy. And it's not in the same court. Karen Reed's lawsuit against everybody was originally filed in state court, but then was removed to federal court. So that is now a federal court case. The federal court case is the one where Proctor's like, help, I need the discovery because my memory and I've got to do a deposition, that one. That's in federal court. There are a lot of things that when we do a deep dive into this case that are interesting and we're going to have a conversation about. For today's purposes, I want to take a look at what the causes of action are, what may happen next, and then an overview of what's being alleged. So let's take a look at the charges first. All right, we are looking first at the causes of action. Count 1 is defamation and defamation per se against defendant Karen Reed. They reassert the entire 35 pages of the complaint preceding this count and say that Karen Reed was responsible for publishing false statements, asserting or reasonably understood to be asserting that the plaintiffs were responsible for the murder of John O'Keefe, a cover-up of their purported role in the murder. They say that Karen Reed published numerous defamatory statements, both directly and through her accomplice, Turtle Boy. They go on to say that Reed's statements were false, that the plaintiffs did not murder John O'Keefe, did not participate in any conspiracy to murder John O'Keefe, did not engage in any cover-up of O'Keefe's death, did not frame Karen Reed for murder. Reed knew that her statements were false because she was present when O'Keefe was struck by her vehicle, made multiple admissions to first responders that she hit O'Keefe. Yep. They also say, and acknowledged to her own attorney that she may have had, quote, some element of culpability in O'Keefe's death. They're pulling that directly from one of the interviews that was played during the second trial. That's where they're pulling that from. They go on to say that the publications were individually defamatory, but also part of a continuous course of conduct starting in 2023 and continuing through today. We'll talk about that more in a moment. They go on to say that the statements contained in the Reed's what they call campaign of harassment and abuse constitute defamation per se. Remember, as kind of a shorthand, defamation per se will follow without needing to prove damages when you are talking about accusations of committing a crime. There are other categories that will count for defamation per se. Those vary jurisdiction by jurisdiction, but accusing someone of crimes is going to count as defamation per se, where you don't necessarily have to show damage because the law assumes accusing someone of crime is damaging to their reputation. They go on to say that Reed's statements were of and concerning each of the plaintiffs. She repeatedly identified plaintiffs by name, and her audience understood the defamatory statements to refer specifically to plaintiffs. And then they go on through alleging the defamation and defamation per se, saying, quote, Reed published her outrageous, cruel, and malicious lies about plaintiffs negligently and with knowledge that the statements were false or with reckless disregard as to whether or not they were true. So it seems to also contemplate in the way that it's pled here that there will be an argument about whether or not they are public figures. So the way that they're languaging that cause of action seems to contemplate that conversation will come up, that they may in fact be limited public figures with relation to this case. And that's a conversation that as we do a deeper dive into this case, we will have more, I suspect. Count 2 is defamation and defamation per se regarding Turtle Boy, realleging everything above and alleging the same types of statements that Turtle Boy published false statements asserting or reasonably understood to be asserting that plaintiffs were responsible for the murder of John O'Keefe and to cover up for their purported role in the murder, and published numerous defamatory statements. And they spend quite a lot of the complaint talking about statements made by him on YouTube, on a blog, in media outlets, and elsewhere. The bulk of the statements that they directly identify are related to Turtle Boy. They go on to say that his statements were false, that the plaintiffs did not murder John O'Keefe, did not participate in any conspiracy to murder John O'Keefe, did not engage in any cover-up of John O'Keefe's death, did not frame Karen Reed for murder. They say that he knew or had reason to know that his statements were false because, A, he received his information exclusively from Reed and her legal team, who were motivated to deflect blame from Reed. Interesting to include that he was receiving information from Karen Reed and her legal team in the complaint where it seems to form at least the beginning of a basis to say that if the lawyers and the defendant were giving him that information, that he was relying on it in good faith. It seems to start to seed that expected and foreseeable argument that they are, I think, trying to mitigate that they were motivated to deflect blame from Reed. Okay, but is that why he shouldn't believe them, or does he have grounds to believe the lawyers? It's just setting up a fight in the way that it's even pled in the complaint, saying that all his information was based off of sources with intricate knowledge of the case. They go on to say that he made no independent journalistic effort to verify the accuracy of the murder accusations before publishing them. So I guess they're trying to allege that it wasn't a reasonable belief, or that it was... Emily, you said you weren't going to debate. I know sometimes it's hard when you see the foundations of defenses woven into the pleadings. When we're just looking at defamation, you start to see where they're trying, I think, to hedge some of the defenses about where this information came from, and if it was a reckless disregard for the truth, or whether it was reasonably relied upon. So they say he made no independent journalistic effort to verify the accuracy of the accusations before publishing them. I mean, talking to the defendant and the lawyer, okay, aside. C, he repeatedly ignored or dismissed evidence contradicting his narrative, not an element of the case here. D, he admitted that he, quote, protected Karen Reed and lied about their relationship to conceal the source of his information. They go on to allege the same things they alleged above with regard to Karen Reed, and that the statements were published. I don't think that's going to be in dispute. Publishing will not be in dispute. These statements were in fact published. No dispute. They go on to say that the publications injured the plaintiff's reputations, have exposed the plaintiffs to public and private hatred, contempt, and ridicule. That languaging is going to be directly from the defamation statute. Remember, defamation is for harm to reputation. Because why, law nerds? Because dueling is illegal. That's right. We have moved on from duels to defamation lawsuits. It goes on to say that these false publications have caused the plaintiffs to sustain actual and substantial damages. They go on to say that, quote, in light of his prior experience with similar sorts of negligent, reckless, and false statements, I don't know what they're referring to in their pleadings, that he knew the publications would cause the plaintiffs to suffer harassment and potential violence. They go on to say that the outrageous, cruel, and malicious lies were broadcast negligently with knowledge that the statements were false, or with reckless disregard as to whether or not they were true. So that's getting into that contemplation of perhaps limited public figures. Count 3, aiding and abetting defamation and defamation per se. As to defendant Reed, they are alleging Reed aided and abetted Turtle Boy's defamation by giving him information. I'm real curious about the case law on this in Massachusetts. So just put a note next to this one, because I'm curious if you can have aiding and abetting causes of action as to defamation. I'm curious about that. Count 4 is aiding and abetting defamation as to Turtle Boy, aiding and abetting defamation by Karen Reed. Count 5 is intentional infliction of emotional distress as to Karen Reed. And this is again pled with the language of the statute, alleging that Reed's conduct was extreme and outrageous, that the conduct was extreme and outrageous, they say, because she orchestrated a coordinated campaign to falsely accuse plaintiffs of murder and conspiracy to frame her, knowing these accusations were false. We'll talk about what this is going to require at a trial, if this goes to trial, because they are going to have to prove that she knew that this was false. They go on to say that she deliberately used an intermediary and encrypted communications to funnel false statements to Turtle Boy for maximum public dissemination, hired a private investigator. They say previously associated with Harvey Weinstein. Why do they say that? To make it look bad. That's why. But again, Alan Jackson was one of Weinstein's attorneys. So if there is an investigator that he uses regularly, that's not shocking. But maybe they think that it will be shocking if they can connect that in headlines. It goes on to say, and celebrated the destruction of plaintiffs' reputations while monetizing the result publicly. Not, I don't think, necessary for this cause of action, but it will come up later. They say that Reed's conduct exceeded all bounds of decency. That, again, is going to go to the statutory language of intentional infliction of emotional distress. They allege that the emotional distress sustained was severe. It'll be interesting to see how Higgins navigates this. It's my understanding, and I mean, this could have changed, let me know in the comments, but it's my understanding he's still employed by ATF. So it'll be interesting to see how they are going to move through the IIED claims and prove that this caused the type of damages you have to prove for intentional infliction of emotional distress. Count 6 is IIED, all plaintiffs against Turtle Boy. So we've got the 2 counts of defamation, 1 for each defendant, 2 counts of aiding and abetting defamation for the one helping the other, 2 counts of intentional infliction of emotional distress, which as to Karen Reed might be more difficult, as to Turtle Boy might be easier depending on the things that he has said on social media, on Instagram. They're alleging that there are statements of him saying that some of the plaintiffs don't ever deserve peace. They don't deserve a moment of rest, things of that nature. And that might play into the IIED, but I think most of that was targeted towards Jen McCabe. I don't think I saw in their pleadings that any of that was targeted towards like Higgins. So these things are broader, and I think will get narrowed down as we've talked about recently in the Lively Baldoni case, but as we've talked about in other cases. So the IIED between like Jen McCabe and Turtle Boy actually might be positioned differently than as to Karen Reed and Jen McCabe, which will be interesting to see how that navigates. Because I could see a jury looking at some of the real world stuff and being like, look, even if you think that they did this, this still goes beyond what a jury might tolerate. It's going to be interesting to see. However, it really is going to depend on the public and potential jury attitude on that. Count 7 and 8 are aiding and abetting IIED from one to the other. But again, I don't know if that's possible. Like, they are not quoting what law they are using. They are not quoting where you are allowed to have aiding and abetting of IIED. I don't think I've ever seen that before. I have some questions on the aiding and abetting charges. I don't know if you can do that. So, question mark. Counts 9 and 10 are negligent infliction of emotional distress. Again, they are alleging as to defendant Reed and as to Turtle Boy that the quote campaign of outrageous, cruel, and malicious lies created an unreasonable risk of causing the plaintiffs severe emotional distress, that the distress was foreseeable, that the distress was severe enough that it resulted in illness or bodily harm, including but not limited to anxiety, depression, sleep disturbances, and other physical manifestations of severe psychological trauma. And then count 11 and count 12 are aiding and abetting the negligent infliction of emotional distress for them helping the others. Then count 13 is civil conspiracy between Karen Reed and Turtle Boy with regard to essentially the above, that they conspired to share information about this case and have that disseminated publicly. And then count 13 is Massachusetts Unfair Trade Practices Act against Turtle Boy, alleging that he was using commerce, being YouTube and blog, in a course of unfair trade, they say, to quote, unethically, oppressively, immorally, or unscrupulously developed, propagated, or disseminated outrageous and malicious lies about the plaintiffs and their family members, and did so for profit. And they go on to say that he operates a commercial enterprise through which he monetizes content by selling subscriptions, merchandise, featuring the plaintiff's name and likeness, though they're not suing for misappropriation of likeness, by advertising, soliciting donations, that the defamatory statements were an integral part of his commercial business model. And they do talk about it a lot throughout the complaint, that it's monetized, it's monetized, it's monetized. And then it ties back into this cause of action. which I have not seen a commercial unfair trade practices cause of action brought for someone operating a YouTube channel and a blog in this way. I've seen it with relation to deceptive advertising with products and things like that. This is a more unique use of this statute. I can't imagine it's used like this in Massachusetts all that often. And law nerds, because you're just as nerdy as me, we're just going to take a look real quick at the section that they cited, which says Section 2A, unfair methods of competition and unfair or deceptive acts or practices in the conduct of any trade or commerce are hereby declared unlawful. I'm interested how they are going to navigate that having a source connected to a defendant or the defendant themselves is an unfair method of competition, or is saying that he wasn't getting information from Kearney, the deceptive act. Law nerd Emily is nerdy curious how this is going to fly, because it's an interesting way to interpret unfair competition and methods. So how does 15 U.S.C. 45 define unfair or deceptive acts or practices? For purposes of subsection A, the term unfair or deceptive acts or practices includes such acts or practices involving foreign commerce that 1, cause or are likely to cause reasonably foreseeable injury within the United States, or involve material conduct occurring within the United States. All remedies available to the Commission with respect to unfair and deceptive acts or practices shall be available for acts and practices described in this paragraph, including restitution. Wonderful. Here's the thing. When we are looking at how these things are defined, and we will do a deep dive another day, I said I was going to do an overview and then I ended up deep diving. But there is going to be case law governing this, hopefully, because I'm very curious how they are bringing in what's been said online into deceptive, essentially, trade practices. After the shallow dive into how are they going to do this, I'm going to just make a note. I have a lot of questions about how they are going to navigate an unfair trade practices in this case. I'm curious where and how that can apply or can't apply. What they say is that the campaign of lies, abuse, and harassment was a deceptive and unfair practice and offended public policy, and that the conduct constitutes unfair methods of competition. With no further explanation, then again, it is a complaint. It needs to just have the magic legal words and the allegations and shade in a complaint, because complaints are allegations and shade. And so the allegations are that the defamation is an unfair trade practice, it seems. The campaign of lies, they call it. That is the last cause of action. The request for relief is judgment in favor of the plaintiffs, damages in the amount to be determined at trial, but exceeding at least the jurisdictional limit, including double or treble damages pursuant to Chapter 93A. Treble damages would be, as you get into like your punitive damages. They go on to then say, award punitive damages in an amount to be determined at trial, award the plaintiff's attorney's fees, costs, expenses of litigation, and prejudgment interest, and any other legal, equitable, or declaratory relief as is proper. So they are demanding trial by jury. And here's what they are requesting truly in a trial by jury. When you are requesting a trial by jury on allegations that defamation occurred when the plaintiffs were accused, and they bring up a lot of statements, more of Turtle Boy statements than of Karen Reed's statements, because they're saying that Karen Reed was funneling things to him to say, and then he was the one saying them. But when the statements are allegations of committing the murder, covering up a murder, to kind of synthesize them down into the bulk of what the allegations are there, committing a murder and covering up a murder. Part of this is going to be navigating that there was a reckless disregard for the truth and showing that the defendants, Karen Reed and Turtle Boy, recklessly disregarded the things that they knew. In the context of going through 2 trials where a jury acquitted Karen Reed, puts this defamation case on different footing than a lot of the other cases we've covered. However, you are looking at conduct spanning over a course of time. I don't know if they will be able to easily navigate because they're alleging statements all the way through. I don't know if they will be able to navigate statements made at the very beginning of when Turtle Boy was covering this until after trial 2, because to navigate that entire course of conduct and alleging an overall conspiracy, then you are going to have to look at the totality of information. It's going to be harder to parse it out and say, okay, well, before trial, there wasn't this information, and after trial, there was. And of course, in this, you will not be surprised based on the charges that we have read that this is quadrupling down. I think everybody is just going to end up fighting Cerberus on this one, but it is quadrupling down on Karen Reed killed John O'Keefe. Again, a hard allegation to navigate when you are looking at the context of a defamation claim, arguing that Karen Reed and Turtle Boy knew the things they were saying were lies, and then trying to prove that when we've been through 2 criminal trials. So the amount of discovery here is going to be wild. The fact that this is in state court has some different aspects than if this was in federal court, but they are alleging that Karen Reed and Turtle Boy knew these statements were true because fundamentally they knew that Karen Reed hit John O'Keefe with her car and killed him. That is the argument. Again, there is going to be a lot of discovery on this case. And why do I say that? Well, let's look at the beginning allegations here, and then we'll talk about where this goes from here. They open their complaint by saying that this case arises from a multi-year conspiracy orchestrated by Karen Reed and Aidan Kearney to subvert and prejudice the criminal justice process in Norfolk County, Massachusetts. They say through a coordinated scheme, Reed and Kearney sought to protect and enrich themselves by defaming, harassing, and tormenting plaintiffs who served as witnesses in connection with the Commonwealth of Massachusetts' investigation into the death of John O'Keefe and its prosecution of Reed for murder. More specifically, Reed and Kearney conspired to defame and did defame plaintiffs by falsely asserting, among other things, that they were responsible for O'Keefe's death, conspired to conceal their roles in his death, and framed Karen Reed for murder. Those are the bulk of the allegations. And then they go through specific statements and kind of tie them back to these assertions that those are the defamatory statements. As timing of this lawsuit, it's interesting to note that in their statement of the case, they talk about Reed laundering defamatory material. And they say, quote, Reed sought to launder defamatory material by gratuitously including it in pleadings filed with the court. For example, on April 12th, 2023, Reed, through her counsel, filed a discovery motion for a second time to obtain Brian Albert's phone, in which she falsely stated that Brian Albert and Colin Albert were responsible for O'Keefe's death and that McCabe was the mastermind who covered it up. Reed knew these statements were false. They go on to talk about the fact that their private information was not redacted from the filings, which I am not a fan of. The courts should have made sure that that was redacted in addition to the lawyers. But they go on to say that information in those filings were not redacted. They go on to say that Reed forwarded the April 12th following to Turtle Boy for him to publish it, and that he published that on April 18th, 2023. Emily, why does this matter? Well, A, statute of limitations on defamation in Massachusetts is 3 years. They're alleging the first publication from Turtle Boy was April 18th, 2023. However, if his statements are all from a public court filing without more, some of that is going to fall under fair report privilege. Now, For fair reporting, it has to in fact be fair. You can't take court documents and then shift it into something completely different and say, see, the court document says it when it doesn't. But if you have court documents where the lawyers are making that argument at the very beginning of this, and then someone takes those court filings and picks up those arguments, there is going to be a big fight over whether or not that's fair reporting on the court documents. And there's going to be a fight, of course, for Karen Reed over litigation privilege and the things that are said in court covered by litigation privilege. So this dates all the way back to April 18th, 2023. But if it's all based on a court filing, there is going to be a fight there over whether what was said was a fair interpretation of arguments made in court or not. And so there is going to be some nuance that I'm surprised anyone wants to fight out in court, because it's going to take a lot of time and money and discovery. And it's going to essentially litigate everything that we saw half litigated in trial 1 and 2 about Jen McCabe's Google searches, what they said in trial, what was known to Turtle Boy when he was making statements, what was said in court documents. Because if you are reporting on court documents saying, well, in this document, it accuses this, that's going to be covered in a couple different ways. But there are some boundaries to when it goes beyond that. But these are incredibly nuanced legal arguments. And then it goes beyond that because, well, a lot of you are going to say, Emily, and I know you're thinking it, Emily, defamation lawsuit, so anti-SLAPP motions, SLAPP being strategic litigation against public participation. Anti-SLAPP statutes in different states are incredibly different. This is filed in Massachusetts. Massachusetts has a very, very narrow anti-SLAPP statute that I don't think is going to apply here, which means this case is not going to get kicked out prior to discovery beginning based on anti-SLAPP, because Massachusetts's anti-SLAPP really is narrowly tailored to actions petitioning the government. And trying to argue that bringing this to light is petitioning the government to maybe get rid of corrupt law enforcement or DAs, that maybe somehow this is petitioning behavior. But what Massachusetts generally looks at as, petitioning behavior is petitioning to the legislature and petitioning to halls of government to change things. It's not as broad as we see in other jurisdictions like California. So anti-SLAPP is not necessarily going to cover this here, and trying to expand the definition of petitioning activity for statements about court proceedings might not be an easy battle to win. And if it's going to be a close call, courts are going to default on letting it go to a jury, not kicking it out. So when we're looking at that anti-SLAPP, I imagine if we see those proceedings sought, it is not going to be just an easy process. That will be an extended, kind of hard-fought litigation on, can the anti-SLAPP even be brought? Does the statements here fall under the anti-SLAPP statute? And then you have to get into the different factors of anti-SLAPP, where then you have to push the plaintiffs to prove that they can go forward. But you don't get to that second phase of anti-SLAPP until you find that the activity complained of in the complaint is covered by the anti-SLAPP statute. And that's not an easy yes here, that like, oh yes, obviously. That's not the case here. This is going to take a little bit of work to even argue to the court that this would be covered by an anti-SLAPP motion, if that argument's even brought. But I know every time we talk about defamation, we're going to talk about anti-SLAPP. Emily, this has not been such an overview. Well, yes. Let me know if you are interested into a deeper dive into this 50-page of, some of it is, these are statements that were made. Some of it is, This is a conspiracy between Karen Read, her attorneys, and Turtle Boy. And some of it is, well, these court documents were then reported, which is going to be an uphill battle. But then again, trying to argue that talking about this on social media is protected petitioning activity is also going to be an uphill battle. And that's only on the defamation, because you still have the intentional infliction and negligent infliction of emotional distress, which would not count under anti-SLAPP, and you still have an unfair practices. So there are some causes of action in here that are going to get further down the line. But if the plaintiffs wanted this to stop and go away, this isn't going to do that. And there is going to be quite a lot of discovery here. And it seems that they already have some access to at least Turtle Boy's phone, which the Lawnards have shared with me. There was some parts of a phone extraction under some circumstance that ended up online. And it seems that these plaintiffs were using parts of that in this complaint to fill in that they had some access to an extraction or access to things that were on Turtle Boy's phone, because things that are being alleged in here don't make any sense unless they had access to that. Then again, there is also witness intimidation charges against Turtle Boy, including these plaintiffs, that are still going forward, which they highlight here as well. They say that in 2023, a grand jury indicted Kearney on witness intimidation charges related to his conduct towards plaintiffs. The grand jury, and I don't know if that's all plaintiffs or just some of the plaintiffs, they don't specify. The grand jury accused Kearney of harassing plaintiffs, charging him with 8 counts of witness intimidation, 5 counts of picketing a witness, and 3 counts of conspiracy to intimidate a witness. So there is a criminal case going alongside of this from 3 years ago that still hasn't resolved. In the Massachusetts extended universe of lawsuits, we have 2 trials of Karen Read with acquittals of everything but drunk driving. We have the wrongful death lawsuit moving forward in state court, the federal lawsuit for malicious prosecution against some of these same plaintiffs moving forward in federal court. We now have a state court defamation case, and then there is also a criminal witness intimidation case. So there is going to be a lot of interwoven litigation that is going to be costly, that is going to be extensive, and that is going to dredge up more than came up in the criminal Karen Read trials. It is going to be interesting to see if the aiding and abetting and conspiracy of defamation can be independent causes of action in Massachusetts. And if we deep dive, I will do some research and see what we can find, because I am very curious. Today was for overview. So the question remains. I'm curious about the unfair trade practices. I think the infliction of emotional distress causes of action may situate differently for each defendant, but aren't going to be dismissed easily on anti-SLAPP. And those are going to be some sticking points, because then you get to intention and knowing intention and wanting to cause and knowingly causing distress. And they are alleging that there are statements that seem to indicate that that was the goal. That again, the other part of that, when you're looking at those causes of actions, is whether or not the behavior is tolerated within society. So the jury gets to decide if it is outside the boundaries to be loudly saying, why aren't you doing anything about these witnesses, if they believe that Karen Read and Kearney believed what they were saying. Now, if a jury believes that they did not believe what they were saying, then it shifts. But then you have to litigate an entire trial about what they were basing their belief on. And that can unearth things that might be known to Karen Read, her attorneys, her defense team, and possibly Turtle Boy as well, that we never saw in a criminal trial. So it raises the question of why this lawsuit, and clearly it seems the plaintiffs want to clear their names and that they believe that this is a vehicle to do it. But you're going to be navigating perception in arguing a defamation case based on what did Turtle Boy and Karen Reed believe based on the information they were seeing versus what the plaintiffs believe based on what they know, what they lived, and what they experienced. And you're going to bump those things up against each other and then look at a jury potentially and say, were these beliefs reasonable? And then when you look at acquittals for Karen Reed on a criminal trial, that becomes, I think, more difficult to navigate on the defamation. You get into different questions as you get into the harassment part of it. It is going to be unequivocally messy. There is going to be a lot more unearthed in this. There was going to be a lot more drudged up. And the plaintiffs allege here that this has divided the community of Canton. I can't imagine that this is going to quell any of that, if not drudge it up more. So we are going to see a lot more litigation. But this lawsuit, why now? Why this lawsuit? Well, it was filed 2 days before the statute of limitations expires. That's why. This is not going to go away quietly. I hope, and I said this before Karen Reed Trial 1 and Karen Reed Trial 2, I hope that maybe this unearths more answers. And I think you know where I'm at the end of 1 and 2. I was like, are there more answers, prosecution? No more answers? Okay, no more answers. I don't know if this will unearth any more answers. I don't know why this isn't part of the defense in the conspiracy of the malicious prosecution federal case, because a lot of this would be defense in the federal case. So I'm curious as to the strategy here to bring a separate defamation case. And maybe it's because of the IIED claims. And though the defamation claims might then garner the headlines, there will be discovery in the federal case. However, Kearney's not pulled into the federal case. So maybe this was the strategy to bring Kearney and Reed both into this defamation case instead of just bringing it as defenses in the federal case. I don't know if we will maybe be able to see the strategy here unwind more, but discovery is going to be part of that. And this then lands with discovery for both parties against the plaintiffs. And we've got so many depositions already pending in the wrongful death case. I can't overstate for you how much litigation this is and how expensive all of this litigation is going to be for everyone involved. This is a lot of litigation, y'all, but if we want to do a deep dive into this, we can do a deeper dive. I expect we will see motions to dismiss, etc. We don't even need to see answers until 60 or 90 days after service. They've already applied to have people served. Yes, people being aware that this exists from the internet does not count as service, but everybody's got lawyers. I imagine the lawyers will just get served and we will start seeing the initial litigation in one more case. But that's not what I was expecting. I expected some of these things really to come up as defenses in the conspiracy allegations in the federal suit. But I guess we'll have to wait and see, because this isn't going to go away anytime soon. And it's going to be messy. And it seems that once again, everyone's going to double down as far as they can get. So we'll see what happens. Lawnards, thank you for being here. Thank you for being a Lawnard. Thank you for letting me kind of take a step back and look at, like, is this even possible under the law? Why are these charges being brought? How are these charges going to play out? How do these charges play into what's going on in the other cases before we get to the, okay, but I know it's right. We're in that situation with the, okay, but we can already start lining up what we saw in trial against what's being alleged here. But it's going to have to play out. And we are going to learn things that we did not see in trial. And there's going to be some nuances to the law here that doesn't make this just an easy, okay, but she was acquitted. What the fuck are we all doing here? It's not going to be as simple as that. And we're going to keep talking about it. So thank you for being here. Thank you for being a law nerd. Thank you for understanding that, well, I travel during the week. Things will be, hopefully not turbulent on my flight, but I won't be streaming. And I will see you back here on the podcast next week. And then we will be streaming to catch up on everything that has inevitably popped off. I will keep you updated in the app. We are working on those of you that are having a little bit of strangeness with your notification delivery. Don't worry, we're working on it. Technology be technologying. Cheers. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a law nerd.